Hi everyone, I'm Sabrina.
And I'm Jonathan, and we are the lawyers at Verity Law.
Today, we will talk about how to choose executors and beneficiaries when you have minor children.
When we pass, all of our assets will be frozen. The executor must then apply to court for an approval document. Once received, the executor will open an estate account and put all of our assets in there. Then the executor will distribute those assets to the beneficiaries from that account.
So, the executor is the person who manages and distributes the inheritance. The beneficiary is the one who receives the inheritance. The executor and beneficiary can be the same person, or they can be different people. Let's take the fairy tale of Snow White to explain this.
Now, Snow White had loving parents, but her mom died when she was young. The king remarried her stepmom. Years later, the king also became sick. He worries about Snow White's future.
So, like most responsible parents, he decided to do estate planning. He went to his lawyers to draft a will so Snow White will be well taken care of when he passes. He wanted to name his daughter to be both the executor and beneficiary, so she will have sole access to the estate account and distribute the inheritance to herself.
But that cannot be done. As Snow White is not 18 years old yet, she is not an adult. Only adults can be named as executors. So, the king considered naming the stepmom as the only executor who will distribute the estate, and Snow White as the only beneficiary who will receive from the estate.
His lawyers asked him to reconsider. Does the queen and Snow White have a conflict of interest? Would the queen take away all of Snow White's inheritance, leaving the princess with nothing?
The king is puzzled, but I specifically said in my will that everything goes to my daughter. If my wife takes everything away, isn't that illegal?
It is illegal, but Snow White would need to formally sue the queen to get her inheritance back. There is no one to supervise the queen and ensure she does everything she's supposed to until Snow White brings a lawsuit.
The king hesitated. He did hear the queen asking her magic mirror, "Who is the fairest of them all?" and saw that she got very angry when it answered Snow White. It doesn't seem like the queen has Snow White's best interests at heart.
If the queen was appointed the only executor, Snow White will probably get nothing. And suing the queen seems intimidating, long, and expensive.
The king asked, "What if you, my lawyer, become my estate trustee? Then I will relax, knowing that you will take care of my estate."
We replied, that is fine, but third-party professionals routinely take 5% of the entire estate as service fees when acting as estate trustees. The king found this to be expensive.
So the king asked if he could add his royal advisor, James, as co-executor. This means that any time the money is to be taken from the estate account, both the queen and James would need to sign an agreement. James can monitor the queen's actions this way.
That is fine. But if James and the queen reach an impasse and cannot agree on something, then the estate is stuck. Until they can come to an agreement, no money can be distributed from the estate.
The king then decided to appoint James as the only estate trustee, as he had watched Snow White grow up and has her best interest at heart.
So, what will happen is, when the king eventually passes, James, the royal advisor, will take his will to the court and get it approved. This process is called probate. With a valid will written by estate lawyers, this approval process is relatively fast and painless.
Once approved, James will open an estate account with the bank and put all of the king's assets in there. He will monitor the account and do some low-risk investments to keep pace with inflation. Once Snow White reaches 18, James will give her all of the assets in the estate account.
What about any real estate? Well, they will be transferred into James's name. The deed of the real estate will just say transmission by personal representative. This means that James is holding the property as estate trustee for Snow White. When the princess becomes 18, James's lawyer can transfer it from James's name as executor to Snow White's name.
The king must ensure that there is no outstanding mortgage on any real estate property that is left to Snow White. If there is, while Snow White can get the properties, she could not get the mortgage. The mortgage was given to the king using his own income at the time of purchase.
So if there is a mortgage and Snow White or James cannot pay it off, then they must either sell the property or refinance the property under Snow White's name. Of course, refinancing will be impossible if Snow White is still a minor or has low income when the king passes.
So the king could consider other options, such as purchasing life insurance or having RRSPs or TFSAs saved up. If those amounts are high enough to pay off the mortgage, then everything is fine.
But what if Snow White squanders all her inheritance in 1 week? She's young and immature.
Well, the king could set up a trust, which would last for 21 years. With a trust, instead of getting her inheritance all at once when the king passes, Snow White would get money year by year. The trust could be set up when the king is alive. It could then be used while he is alive and after he passes to give Snow White annual income.
Now that the king has finished his will, he is relaxed and content, knowing that Snow White will be well taken care of. But another thing is bothering him.
He doesn't trust the queen to care for Snow White after he passes. Truthfully, he also doesn't trust her to care for himself once he is old and gray.
As the king is much older than his young wife, what happens if he becomes bedridden with old age? Will she take all his money and pick up and leave? How will Snow White care for the old king if they have no money left?
So, we suggested that the king do a power of attorney. This is a document that appoints another person to handle his financial and medical affairs if he is bedridden or unconscious. Again, the POA must be at least 18 years old.
So the king chose another royal advisor, Aaron, who has been with him for many years. With the POA for property, Aaron only needs a doctor's note saying that the king is bedridden or unconscious, then he can manage the king's financial affairs. He can protect the money in the king's bank accounts and take out funds for the king's medical expenses.
With the POA for healthcare, Aaron can make medical decisions for the king once he is unconscious. So if the queen says, take the king off life support and move him out of the castle, Aaron could object and insist that the king receives treatment and remain in the castle. Without a written POA, the doctors would need to follow the queen's wishes because she is the spouse. With a written POA that has 2 witnesses, the doctor would follow the POA instead and listen to Aaron.
This is why will and POAs are typically done together at the law firm. Doing them all together is also less expensive.
In conclusion, it is crucial to have your will and POAs and trust in place if you have minor children. Amongst other things, it will decide who will care for you when you get older and who will get your assets and your children's custody when you pass.
If you have specific questions about your estate planning, please use the link below and book a free consultation with us. We hope this video was helpful. See you in our next month's video.